Hello, Kevin Lemley, criminal defense lawyer here in Central Arkansas, offices in Little Rock, Cabot, and Searcy. Today we're going to be talking about speedy trial, what that means for you, how it's there to protect you in some situations, but how it's used to work against us in other situations. So when we want to talk about this, the American justice system has something great about it, in that we can't just throw you in prison for years and maybe we'll get to a trial, maybe we won't. So it's actually like that in other countries. You know, you'll hear about this in countries in Africa. They don't like somebody, so they'll just throw them in prison for 5 years. There's no trial, no due process, nothing like that. So what we have in Arkansas to protect us from that is the moment they start the criminal proceedings against you, which generally begins with the arrest, they have exactly 1 year to have the trial, all right? So if they're not able to bring the trial in that time, the case is going to get dismissed. So the judges are really concerned about this. They don't want to get in trouble with their reports or with their administrative oversight, because that's terrible for them if a case gets dismissed just because they couldn't bring it to trial in time. And then same thing with the prosecutor. They definitely want to avoid that. So everybody's always mindful about where are we in speedy trial. So when we're looking at it from the defense side, more often than not, a delay is going to help us. We want to keep pushing it off. It can only help us get our stuff ready. Maybe something's going to happen to the officer, whatever. So what you'll see in those situations when we're asking for a continuance, then we'll say, we take the time, or the judge will say, time to the defense. And so what that means is whenever we ask for those continuances and we get those gaps where we take the time, that doesn't count for speedy trial. So that's all. And even with Cabot, I've had success extending a case out 2 or 3 years, but it doesn't affect speedy trial because we took the time in all those situations. So that's how it works for us. Now, how it can work against us, when you get these smaller courts outside of Little Rock, sometimes they take this very much to heart. And so what they'll do is the case starts and they'll just set a jury trial in like 6 months. And that's not a lot of time to get ready for. And they'll just say, all right, well, that's it. Like, we can't move it because it's speedy trial. So in those situations, it really gets kind of held against us. And then sometimes we'll get these calls from folks in these smaller counties and they'll go, hey, can you represent us? Well, sure we can, but we can't do much of a payment plan because the judge is fast tracking this to trial. And if they're going to fast track it like that, it's not going to help us much at all. With certain filings, like if we do an Act 3 filing where we're going to claim you're not mentally fit to be held criminally responsible, that's going to toll the time. So the whole time that the Act 3 is pending, it's not affecting the speedy trial. And we do get some cases, they get held up on the Act 3 for 6 to 9 months, but that's not going to affect us as far as speedy trial is going to go. Other big thing that we want to bring about is there's a disagreement between the defense lawyers and the courts over how is speedy trial affected because the court is backlogged. And this is where Cabot is rearing its ugly head again. Because remember, Cabot hit and it basically shut the courts down for a couple of years. Well, they weren't holding trials, so it backlogged everything. So we're still seeing that, especially like over in Pulaski County, it's very, very backlogged. So what those judges, they're taking the position of, well, it was because of a pandemic, so it doesn't affect speedy trial. We get all the time that we want if the backlog is because of that. So we're raising those objections. And what we're doing in Pulaski County, we're showing up saying, hey, we're ready for trial. They're saying, no, we don't have a spot for you, so we're just going to push it out, and it's not going to affect speedy trial. Now, as far as I know, that hasn't been challenged up by the Supreme Court yet. That's how it's working, at least in Pulaski County. So they're doing that to us. We're raising the objection, but they're able to put it off. But at the end of the day, speedy trial is there to protect you. You can't just linger around in prison without them ever bringing you to trial. They can't hold it over your head for 10 years or 12 years. But if they want to take it very literally and fast track this thing, then it does make the defense more problematic. But that's how speedy trial works in Arkansas.